Okay, so most of you have probably ripped a CD before, or maybe copied a DVD to your computer, or possibly you've downloaded user-created content for your favorite video game. Did you know that in many cases this is actually illegal? Due to the changes in technology that define this age, laws involving the copywriting of intellectual property need to be amended so that they no longer stifle creativity. I, like most of you, use the internet every day and have seen the negative effects of these restrictive copyright laws. Because of this, I explored some other options that could work as compromises between the current laws and no copyright laws at all. Today, I will discuss how this issue could be solved with hopefully both sides being content with the solution. First, I will explain exactly what intellectual property is and what the current laws are. Then I will show how these laws are restricting creative thought, and finally I will offer a compromise that would protect intellectual property while still allowing creative content to be created. But before we can offer a compromise, we first must understand what the laws currently are. So, what exactly is intellectual property? According to the World Intellectual Property Organization's website, intellectual property is any sort of creation of the mind. It falls into two categories. You have copyrights, such as music and movies, and industrial property, such as patents and trademarks. All of this falls into one category when dealing with copyright laws. Copyright dealing with intellectual property is basically governed by three different laws. You have the WIPO Copyright Treaty that was ratified in 1996, and that was followed by the No Electronic Theft Act in 1997. Together, these laws basically said two things. That first, the creators of intellectual property have the sole rights to the sale and distribution of their products, and that it was illegal to copy intellectual property even if it wasn't for profit. Previously, before the No Electronic Theft Act, you could copy software as long as you weren't making money off of it. But once this was ratified, you can no longer copy software no matter what. In addition, the WIPO Copyright Treaty also stated that publishers of intellectual property are the only ones that could put their creations online in any way. So this basically said that if someone was making like a YouTube video and wanted to include a song, they couldn't if they weren't the original creators of that content. But the most important law is the Digital Millennium Copyright Act that was enacted in 1998. This act made it illegal to circumvent the anti-piracy measures that are included in most software, music, and movies. In response to these anti-piracy measures, a lot of people began creating software and devices that could go around those so that you could, like, say, make a copy of a DVD to your computer so you would have a backup or you could take it with you, stuff like that. But after the DMCA, you can no longer do that. In addition, it also made it illegal to manufacture, sell, or distribute devices that could even potentially be used to copy software illegally. Many of these devices also had legal uses, like I said before, making backups of your DVD collection, which falls under fair use and technically you should be allowed to do, but because of this law, you no longer could purchase these devices. You can think of this as similar to like a photocopier. A photocopier has both legal and illegal uses. You can copy your own notes that you created, or you could copy an entire book and sell it. But a photocopier is still illegal, and so it doesn't really make much sense to make these devices illegal as well because they have both legal and illegal uses. While it may seem that many of these laws are helpful and necessary, many of them, particularly the DMCA, have been heavily abused. As seen in the article, The Digital Millennium Copyright Act is Not Effective by Deirdre Mulligan, there are many ways that the DMCA have been misused. There's basically two court cases that explain this. The first is a company known as Tecmo suing their own customers. There was a website known as ninjahacker.net, which hacker in this case not really being used in a negative term. They were actually just taking the software and making it more useful. They had purchased various video games, so they legally purchased these video games and created custom content for their characters and then traded this content online for free. So they weren't making any money off of it, they weren't stealing anything, but Tecmo still did not like this and forced them and sued them. And so they forced them to take down the website. So Tecmo is using the DMCA to get rid of user-created content because they were afraid of competition. Another similar case is the case of Sony versus a software developer for the dancing robotic dog known as Ado. Ado came with some pre-programmed dance moves, but this software developer created some new ones and then, like the owners of Ninja Hacker, distributed this material for free. Once again, not stealing anything, he wasn't making any money, but Sony didn't like this either, claimed that it was illegal and forced the creator to take down the website. So Like Tecmo, they didn't like this free custom software because they were afraid of competition. After much debate, the program was actually put back on the internet, but it was still a good the fact that this was even a debate proves how stifling these laws can be when it comes to creative content. So as you can see by all of these examples, something needs to be done so that the DMCA cannot be used to prosecute innocent people. So the DMCA is the real problem. A new law needs to be enacted that will protect intellectual property without being overly restrictive. While I will agree that people's creations do need to be protected, laws like the DMCA are not the way to go about it. As I showed with those two court cases, it gets abused more often than it's useful. Many times, large corporations will use the DMCA to get rid of small companies or something like that. And in some cases, copying or cracking software is not done for morally wrong reasons. People are simply trying to use their own software in ways that are better for them, like maybe making a mixed CD off of their iTunes library. In many cases, this is difficult due to the copy protections that is included on many CDs. So while in the past it would be considered stealing to reuse or copy someone else's intellectual property, laws need to change with technology. A really good example of this can be seen in Larry Lessig's speech about intellectual property. He states that at one time planes were considered trespassing if they flew over private property. This case went to the Supreme Court, but they ruled that laws need to change with the times. That yes, at one point this would be considered trespassing, but due to this new technology, we just needed to move along with it. The same logic applies here. Also, in many cases, innovation is being crushed due to lawsuits involving the DMCA. People are afraid to innovate because they're afraid that large corporations such as Sony will sue them, and they're just going to end up losing a lot of money. So my solution is, if no money is being made from this copyright infringement, then there should not even be the possibility of a lawsuit. So by making certain changes to the current laws, we can make everyone happy while not stifling creativity. In conclusion, our current intellectual property laws are not effective and should be adapted. These laws stifle creativity and prosecute many who are not really committing any crimes. The most important copyright law is the Digital Millennium Copyright Act, or the DMCA, which makes it illegal to remove any sort of anti-piracy measures that are included in software. This law has allowed large corporations such as Sony and Tecmo to stop competition and free user-created content. A law should be enacted that allows people to borrow intellectual property as long as they are not making any money off of it. You see user-generated content every day. You see it on YouTube, you see it on Google, all sorts of places on the internet. But think about how easy it is for large corporations to put a stop to it and how innovation is being brought to a halt by laws such as the DMCA.
Okay, questions?
Do you believe that removing laws such as the DMCA would discourage some artists who rely on their creations as a source of income?
Well, I think that you can still make money off of it. Like there's certain authors, such as like Cory Doctorow, one of my favorite authors, that actually gives his creations for free online. But he's still able to make enough money through like donations. People still do buy the hard copies of his book because they want to support him. And he's able to still live off of his writing even though he basically gives it away for free. And also online you can make money off of things like ads and stuff like that where Google will pay you and stuff, things like that. So I think it's still, I don't think that that would turn into an issue.
Okay, one more question.
What are like the consequences for breaking one of these rules?
You can basically get sued. You can be forced to take down your content off the internet. You can lose money.
Does it happen a lot? Like,
yeah.
Is this really highly regulated?
Yeah, like the two court cases that I showed were from a list of like probably 10 or something like that. Where large corporations like Apple will sue people a lot. They sued another. Basically the equivalent of an iTunes store just run by another company. They said that was copyright infringement. So yeah, stuff like this happens a lot, especially if corporations are afraid of competition.
Okay, thanks, Rhiannon.